had to buy a box this big, like this, like that, for all the hangers and all of that. She went through. All her clothes is like she's got. That's your mother-in-law? Debbie, oh, yeah. Session. You may be seated.
State versus Tyler Joseph Hadley, 2011, 2340, please.
Sir, over here, please.
Let the record reflect that Mr. Hadley is present with counsel.
Thank you, Judge.
All right, the first thing I want to do is I want to address the state's request for court to advise the defendant of sentencing options post-Miller. Let's address this first so we know exactly what we're doing before we begin the plea colloquy. So, Mr. Baccadell, I want you to go ahead and tell me your position on this and what you think the court should do at this point.
Right, so, you know, we litigated these motions, which I call kind of post-Miller motions the other day, and one of the motions the defense raised was a request that the court advise the defendant of the minimum mandatories. And again, we litigated that issue, but what I made very clear at that point in time is, look, we're moving towards trial. This matter's set for trial. We anticipate there's going to be a trial. We're not talking plea negotiations or changes of plea, so you know, that issue is really kind of was premature. But what I did acknowledge, and I think I acknowledged it not only in that motion, but I wanted to reiterate it in the motion I filed with you yesterday afternoon, is we all recognize that Miller authorizes the court, and you've already concluded this, that the Miller authorizes this court to sentence the defendant to life in prison without the possibility of parole after the youth mitigation hearing. Now, in the event, at the conclusion of that, and quite frankly, just what I intend to do is offer my case at a sentencing hearing, albeit a truncated version of my case, outlining the aggravating circumstances which I think will warrant a life in prison without parole sentence. If the court determines at the conclusion of that sentencing that whatever mitigation they elect to put on outweighs, if you will, my aggravation, and you are not going to impose a life without parole sentence, I think we all need to know at this point in time what you would intend to do. It's not asking you to prejudge the case. It's just simply ensuring that the defendant has a full understanding of what the possible consequences of his plea are here today. So that's the gist of that motion.
Well, in the last sentence, you said, in this vein,
right,
should the defendant enter a plea in this case, the state will respectfully suggest that the court advise the defendant that his sentencing options are life in prison without the possibility of parole, or life in prison with 25-year minimum mandatories run consecutive to one another.
Right.
You're saying those are the only two options, including making consecutive sentences?
Yeah, well, you could make it concurrent.
Okay.
Yeah. All right. Well, excuse me. That's what I'm going to ask for. I want him to know what I'm going to see.
But the options.
Yeah,
though.
sure. Right. Okay.
So let's come back to whether or not. And I think your position is that I would have to declare that the statute is unconstitutional as to him,
right,
in order to get away from the life without possibility of parole.
It would be unconstitutional as applied, given the facts and circumstances.
And your argument is that if I say that the statute is unconstitutional as applied to him because of his age and mitigating factors, that we go back and revive the 1993 version of 775.0821, which requires a minimum mandatory of 25 years.
That's correct.
With possibility of parole.
That's correct.
Ms. Whitney.
Judge, I don't know why we're even talking about this motion response, request. I never, in 32 years of handling criminal law, I've never, ever seen anything like this.
Well, have you ever been faced with a situation before?
Judge, yeah, we faced it last week. We faced it at the hearing. The court ruled it's over. Why we're going back, and Mr. Backdahl is wanting to rehash all of the things he argued a week ago, I cannot for the life of me understand. Let me read for you, please, what this court said at the hearing at the time we argued these motions. Page 27, line 15. This is the court. I think it's clear that the court, if there is a finding of guilty on both counts of either count of first-degree murder, that the court has to hold, I think the phrase is, a juvenile mitigation inquiry. We agree. And after that inquiry, the court would have the authority to either sentence the defendant to life in prison without parole, which we all know is true, or to sentence any other sentence that would be appropriate, which would include, we agree, 25 years minimum mandatory with the possibility of parole. Judge, we agree. That's an option. Life without the possibility of parole is an option. And any other sentence this court determines after the mitigation hearing is held deems appropriate. The court ruled, you signed an order, it's over. Further, Mr. Backdahl says, on page 28, line 22, the court, I'm sorry. So if convicted of first-degree murder on either or both of these counts, does the state wish to respond as to what the minimum sentence would be? Mr. Backdahl, there is no minimum sentence. Judge, it's over. You ruled. We can't readdress this.
Unfortunately, the grave misunderstanding on Ms. Liddy's part is the difference between a trial and a plea. When we went to trial, the point was to advise him the maximum he was looking at his life. I didn't bring us here today. This is not my change of plea. This is their change of plea. Now it's our obligation, you, me, and Ms. Liddy, to ensure, pursuant to the rule I cited in my motion, that he has a full and complete understanding of the potential sentences he could face as a result of entering this plea. That's all I'm doing.
And Mr. Backdahl...
Wait.
So I don't see that my position is inconsistent. When we spoke last, we were all proceeding towards trial. We have been proceeding towards trial for 2.5 years. So I argued it from the perspective of we're going to trial. All he needs to know is the potential of life at trial. He's now pleaded. He needs to know what the potential consequences of his plea are. I have a obligation on behalf of the people of the state of Florida to ensure finality. That when he walks out of this room today, if he enters a plea, and if you accept it, that it's done. That I have no direct appeal issues, that I do not have any challenges to Ms. Liddy's representation. It needs to be over. And this simply is fully informative. Now, if you say, and you're free to say, I am not going to invoke the doctrine of statutory revival, then so be it. That's for you to determine. But I think, based on my motion, that's the only route that we have available to us. So that's, I guess I'm just kind of dumbfounded by the confusion.
Okay, so are you contending that I cannot impose a term of years?
Yes.
Judge, that's not what the court ruled. That's not what, based on your ruling, the transcript, your order. Mr. Hadley was here during all those hearings. He heard what the court said. We've advised him based on what the court ruled. The law is clear, and the court agreed. The court can consider, only after a mitigation hearing, the court can consider life without the possibility of parole. Absolutely, we know that. Mr. Hadley knows that. The court can consider statutory reversion, but the court can also consider any other sentence as the court ruled February 6th at the hearing motion. Mr. Backdahl is simply trying to get the court to prejudge this case, to prejudge the sentence, and it's not necessary. Mr. Hadley is here before the court to take responsibility for his action.
Okay. So if I advise the defendant before we proceed with this plea colloquy, if there's a possibility that he could be sentenced to life in prison without parole after the juvenile mitigation hearing.
Right?
He could be sentenced to, after mitigation hearing, he could be sentenced to a minimum of 25 years with the possibility of parole to follow, either as consecutive or concurrent.
Right?
Or he could be sentenced to a term of years without a minimum mandatory. Does that
Absolutely.
meet your requirements?
Absolutely.
I'm not committing.
Oh,
I'm
we understand
I'm saying
that.
that those are possibilities. The state may disagree with the term of years, but as far as advising him of whatever possible sentences, the state satisfied that would advise him of the possible sentencing scenarios?
Well, I mean, and ultimately, I guess that's my concern, as I had articulated in my original motions, the only court to rule specifically in the alternative, in light of Miller, the alternative sentencing, is the 5th District Court of Appeals in Horsley. And Horsley, of course, being it's the only court that's ruled on it, is controlling. And the Horsley court saying the only remedy is statutory revival, that a term of years is not a viable option. I think that if you go back and you look at Partlow, which I cited to you, and you look at Justice Maycare's concurring, dissenting opinion, if you will, he clearly articulates how a term of years is simply not a viable option. There is no, it would be a total act of judicial activism. So here's my point to you, Judge. If you tell him that, and you're wrong about that, guess what he's going to do? In 2 years or in 60 days or whatever, when he files his appeal and say, look, when I entered my plea, the judge told me a term of years was an option. And now I learned, because the Supreme Court's ruled on this, Florida Supreme Court of the 4th, that term of years is not an option. I never would have entered my plea but for that fact. Okay? And then we're all back here in 2 years. That's my concern. That's why this is the present state of the law. If you tell him right now it's life or it's a possible 50 years minimum mandatory, and he says, you know what, the heck with it, I don't want to plea, we got a jury coming in, let's roll. But I think to talk about a term of years is a potential can of worms which could keep this case moving forever. That's why I did this. I don't think this should come as a big surprise to anybody.
I
would prefer it if she'd not direct her comments.
I'm sorry, Judge. I'm sorry. It's surprising because we already went through this. We talked about Horsley. We talked about Partlow. We talked about all of this, and the court ruled, and we got the transcript. And that's, Judge, what you just said is absolutely the law, absolutely appropriate. We're ready to enter our plea. We're asking the court to go forward.
Well, as we all know, there's no hard and fast ruling on this because it hasn't been submitted apparently to the Florida Supreme Court.
Exactly.
The legislature hasn't responded with some of the issues been raised by the Supreme Court decisions, I guess. It's influx. But I believe that if I instruct Mr. Hadley, as I said before, that the sentences are life imprisonment without the possibility of parole after a juvenile mitigation hearing, a sentence of each count of minimum mandatory of 25 years, either concurrent or consecutive, with the possibility of parole after that.
Right.
Or there is a possibility that he could be sentenced to a term of years without a minimum mandatory, but that term of years could be, there doesn't seem to be any cap on the term of years.
Judge, that's what we said the other day.
I understand, because I've seen some cases we held, I think it's 99 years, I think they held for a juvenile was not, did not exclude the possibility of parole.
Judge, I understand this is it's all over the place. That's what, you know,
So I
we
believe
understand that.
that if I instruct him and if I rule that way, that those are the possible sentences that can be imposed, that he's aware of what possible sentences. That's not a commitment by the court as to what I'm going to do. It's not a promise. I still have to go through all the other things to get to that point, but at least he knows that those are options that may be available to him, not binding upon the court, available for the court to listen to all arguments, all evidence presented, to make a determination whether or not the statute is unconstitutional as to him, whether as a result of that, statutory revision brings up the old statute, or whether term of years is an option for the court to exercise its discretion.
We agree, Judge. Thank you.
Okay. Having done that, is there any legal reason why we should not proceed with change of plea?
Yeah, a couple things we're probably going to need to take up. The first is I had conversations with the defendant's attorney relative to today's proceedings, and I had indicated that I intended to inquire of the defendant regarding the knowing and voluntary nature of his plea pursuant to the rules of criminal procedure. Apparently they're expressing an objection to that, so I guess we should address
You're inquiring
that.
or the court inquiring?
Well, no, you're inquiring, but I'm going to have some follow-up questions before the plea's accepted, as is a common practice.
It's not common
It will not
practice.
invade attorney-client
No,
privilege?
of course not.
Okay.
Oh, Judge, it's not common practice, but we're asking, well, I'm imploring the court that if Mr. Backdahl doesn't think you ask enough questions, he has some more, we're fine with that. But I'm asking that Mr. Backdahl tell the court what questions he wants asked, and the court ask Mr. Hadley, please.
You know, Judge, I'm not...
Wait. Why not just have Mr. Backdahl ask questions and you can assert any objections you have at that time?
Judge, it's inappropriate. I'm asking the court, please, if Mr. Backdahl wants to... He has said 50 times in the newspaper, on TV, everywhere, this is not a negotiated plea. We're not agreeing to anything. This is a plea to this court. Mr. Backdahl has nothing to do with this. Nothing.
Well, I think he has the obligation to make sure that it's freely and voluntarily made. He understands all of the consequences of this open plea.
I
We all have
absolutely
that
agree.
obligation.
We all have that obligation, and I agree. Mr. Backdahl is absolutely free to inquire of the defendant through this court. It is a plea to the court. We're asking the court, please, to do the inquiry.
Well, as I've done other changes to plea, sometimes the state attorney will have additional questions because of the circumstances of the particular case.
I
They want to make
understand.
sure that there's because sometimes the state may be aware of issues that I'm not aware of, that they want to make sure they're covered. So I don't have any problem with Mr. Backdahl inquiring of the defendant. You can assert any objections you want. I believe he understands. He said he's not going to inquire of any privileged communications. But in order to make sure that this case is completely done within the rules, and that we make sure this defendant is entering a plea that is freely, voluntarily, and knowingly made, I'll allow him to make the inquiry subject to your objection.
Okay. Judge, for the record, I would like to point out, I think there is no rule of criminal procedure that I am aware of that allows the prosecutor to cross-examine the defendant when he's trying to take responsibility and enter a plea. If he can point me to the rule that he just said is in the rules.
The same rule I
Let's do
put
it.
in my motion, so yes, I will enlighten you as to Rule 3.172.
No, you didn't put anything in your motion, Tom.
Or he did.
I respectfully, Your Honor, I think it's inappropriate that she refers to me by my first name.
Oh, I'm sorry, that was one time. I'm
Go
sorry.
ahead. Go ahead.
It's in my motion.
I know it's in.
Okay.
All right, now there was another thing you said, there were two things you wanted to raise.
Right. So, okay, so that's because the state is not a potted plant in these proceedings, I've asked to inquire. I have an issue with regard to the language written in by somebody from the defense team on page 4, and it reads the
Page
possible...
4 of what?
The plea.
The plea.
Judge, do you want a copy?
Yes.
Or I'll give you the original. And Judge, if I can just, before he talks about the plea form, I want to make the court aware that Mr. Backdahl asked me yesterday if he could please see a copy of the plea form that Mr. Hadley signed prior to this hearing. I emailed it to him yesterday afternoon. He filed this motion after,
What motion?
or whatever it's
What?
called.
Request.
Request.
Okay.
After
you-
he's seen the plea form, if he had any objection to what's in it, I don't know why he didn't put it in this, but anyway, he's had plenty of time to review this and call me if he had any problems.
Okay, what's the problem with the plea form or the issue?
Okay, somebody wrote into the plea form that a juvenile cannot get life without this is after the maximum possible penalty, that the juvenile cannot get life without parole unless he is found indistinguishable from an adult. I presume that's Miller language. I don't see why in the world that is contained within the plea form. I think it's inappropriate. I don't think it should be there. And then it talks about afterwards he's entitled to a mitigation hearing where the court can consider a lesser sentence. Again, I think it's superfluous, it's unnecessary. That one I don't have as big an objection to because you're going to tell them that, but this indistinguishable from an adult. Here's, again, I have an interest in finality, as you do. I have an interest in finality. I'm not going to be here in 3 years and drag this family back in to relitigate these issues because they allege ineffective assistance to counsel or a misunderstanding. So I think to add language of that nature is not necessary, and it only creates potential confusion and problems. So I'm just asking that language be stricken this indistinguishable from an adult language.
Where does that language come from?
Miller v. Alabama.
That's the phrase indistinguishable from adult. That's language from Miller?
Yes, sir.
And I don't remember it from Miller, and I read Miller 10 times. That's not to say it's not in there, but I do not recall it.
Judge, I think...
Except for the exact word, the meaning is correct, isn't it?
That you have to find he's indistinguishable from an adult?
Except for that word, I have to find that he should not be treated the same as an adult.
That he should not be treated the same as an adult? After a hearing.
You know, without parole.
No, I think that, well, I think the presumption is that he's not to be treated the same as an adult, and I'm going to have to overcome that presumption at sentencing. I'm going to have to show why he should be.
Okay. Anything else on this issue?
Judge, and I want to be upfront with the court. This language was also in the Harvard Law Review article that I submitted when we filed our motions. This is the spirit of Miller. I do not in any way want to tell the court that the word indistinguishable is in there, because that I'd have to find it before I agree to that. But Judge, this is language from Miller.
I think the context is correct.
Yes.
That unless I find some reason not to treat him differently,
Right.
He would be sentenced to life without the possibility of parole.
That's correct.
Okay. So I will not require the language to be stricken from the plea agreement. Okay. Let's back it on. Was there something else before we proceed?
No, sir.
I do have one side issue, Judge, with regard to the motions that we did file and the court did order. We want to make sure the court is aware, based on the dialogue we've had the last few minutes, that we are entering the plea, reserving our right to appeal those the denials of the motions that we did file.
Okay. I guess maybe I'm mistaken, but it's my understanding that if you enter a plea, he waives his right to all appeals. I really don't care if they appeal the Miller motions, but they did file a motion with respect to McNaughton. And I think that motion is not preserved for appeal. I would object to that.
And I agree with Mr. Baccadoff state that we are waiving that issue because of the entering of the plea on the McNaughton motion, but not the other three.
Now, he's entering plea of no contest,
Yes.
not guilty.
Right. No contest, Judge.
Anything else?
Well, yeah, maybe, I guess, they brought it up. So in the event that this plea goes through and we proceed to sentencing, another conversation that was somewhat off-putting that I had with the defendant's attorney was that I had indicated that I anticipate the need to have a rather extensive sentencing hearing. I fully intend, as I've indicated previously, to put on evidence regarding the defendant's activities with respect to murdering his parents. And apparently there's an objection to that from the defense. And I guess we ought to get that figured out before, that's the objection out. I was told that there was an objection. So if there isn't, then we can proceed.
We know he's going to put on it. He already, I think he said on TV, he's going to do 3 or 4 days of the facts and circumstances of this case. We understand that, Judge. We've spoken to Mr. Hadley.
Okay. Are there any other issues before we proceed with the plea colloquy?
No, sir.
Okay. Mr. Hadley, will you be sworn by the clerk, please?
Raise your right hand.
Do you swear or affirm that the evidence that you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
State your name, please.
Tyler Joseph Hadley.
All right. Ms. Liddy, my understanding is at this time he's entering pleas of no contest as charged to count 1, first-degree murder with a weapon, and count 2, first-degree murder with a weapon. And this is an open plea. There's no plea agreement between the state and the defense as to what sentences to impose. Is that correct?
That is correct, Your Honor.
All right. State your name again, please.
Tyler Joseph Hadley.
Sir, Mr. Hadley, I need you to speak up. This is being recorded. I want to make sure that you're being picked up on the recording. I'm going to ask you to, I know you may have a little difficulty doing that, but I'm going to ask you to keep your voice up to make sure you're recorded, okay?
Sure.
All right. You've now been placed under oath. I'm going to ask you some questions now to determine if your plea is being entered freely, voluntarily, and knowingly. And since you've been placed under oath, I'm entitled to rely upon your answers to those questions in making that decision. You understand that, sir?
Yes, sir.
Just to make sure we understand, we're having a plea colloquy here now. This is going to be recorded. Transcript can be prepared at a future date. It's going to go over exactly what we're doing in this plea colloquy. The purpose of this is to make sure that you're entering this plea freely, your own free will, knowing that you know all the circumstances you need to know, and it's voluntary. So I'm going to be asking you some questions. If you don't understand anything that I ask you, anything that I say, anything that either your attorney says or the state says, please let me know right away so we can address it. I want to make sure you understand exactly what we're doing completely. Do you understand that?
Yes, sir.
If you do not raise an objection or raise a question, this record's going to show that you did not raise them, and you apparently were satisfied with everything that happened and understood everything that happened. Do you understand that, sir? Okay.
Yes, sir.
Now, I'm saying this to you now because we're going to do this plea colloquy, and if I accept your plea... I can't hear it.
Yeah, get the...
You're going to have to keep your
Yeah,
voice
you got to
up,
speak
okay?
up, Tom.
We're doing this now because if I accept your plea, later on I sentence you, and you're in prison, and you're talking to people in prison, jailhouse lawyers, and they tell you, man, you were railroaded, you shouldn't have done this, go file a motion for post-conviction relief, claim your lawyers are incompetent, claim you didn't understand, you didn't know what was going on. This record's going to be a written transcript of exactly what we said. And this case law that says that if that record shows that you had every opportunity to object and to raise a question and did not do it, you're probably going to be prohibited from raising that at a future date. Do you understand that?
I understand, sir.
The purpose of this now is to, any questions, any issues, now. Don't wait until you get in prison and raise a couple years later from now. Understand that, sir?
Yes, sir.
Okay. All right. My understanding is you're here today to enter pleas of no contest to 2 charges. First-degree murder with a weapon. First-degree murder with a weapon is to count 1, and first-degree murder with a weapon is to count 2. Each of those charges has a maximum penalty of life in prison without the possibility of parole after a juvenile mitigation hearing. Do you understand that, sir?
Yes, sir.
That is the maximum penalty that could be imposed. Do you understand that?
Yes, sir.
There may be other penalties, but that's the maximum. Do you understand that, sir?
Yes, sir.
And do you understand that by entering these pleas of no contest today, that you are giving up your right to a trial on both of those charges?
Yes, sir.
And you're giving up the right to require the state to prove both of those charges beyond a reasonable doubt. Do you understand that, sir?
Yes, sir.
Okay. Now, Mr. Backett, I'm going to ask you to do what I said before I asked you about the lessers. Explain something to you also. That if you did not give up your right to a trial and you went to a jury, for a jury to decide your guilt or innocence of these charges, there are some lesser included charges that you could have presented to a jury that they could come back and make a finding of guilty on some lesser charges. I want you to make sure you understand exactly what you're giving up by not having a trial. You're giving up the right to have a jury select from a number of lesser charges, which would be lesser penalties. And I'm asked to back about to read to you a list of all the lesser included crimes that a jury could find you not guilty of, and the maximum penalties for those lessers.
Your Honor, the following are Category 1 lessers that we believe the defense would be entitled to at trial. As to each count, second-degree murder, which carries a maximum penalty of up to life in prison or a term of years up to life in prison. A lesser included of manslaughter with a deadly weapon, as to each count, which could carry up to a maximum of 30 years in prison, or simple manslaughter, which could carry a maximum up to 15 years in prison.
Those are all the lesser included?
Those are the Category 1 lesser included.
Are there any other lesser included that you think would be applicable?
No, Judge, that's fine.
So those are all possible convictions and possible maximum sentences that you are giving up by not having a trial and not having a jury decide that issue. Do you understand that, sir?
Yes, sir.
Okay. Now, also, as a result of entering these pleas of no contest today, you're giving up your right to have your attorneys question any witnesses and all the witnesses that the state has to call against you. Do you understand that?
Yes, sir.
You're also giving up the right to have your attorneys call any witnesses to testify for you. Do you understand that?
Yes, sir.
You're also giving up whatever possible defenses you may have to these two charges. Do you understand that?
Yes, sir.
Including a possible defense of insanity. Do you understand that, sir?
Yes, sir.
And was there involuntary intoxication, or is that
No.
what else
No.
subsumed
No.
in the insanity?
Yes.
Okay. You understand, you're giving up all of those things. To cross-examine, to call your witnesses, and you're giving up a possible defense of insanity. Do you understand that, sir?
Yes, sir.
Also, by entering these pleas of no contest today, you're giving up your right to remain silent in that trial or to become a witness and testify. Do you understand that, sir?
Yes, sir.
And you also understand that if you are not a citizen of the United States, that you could be deported as a result of these no contest pleas.
Yes, sir.
And is the defendant or his attorneys aware of any DNA evidence which would indicate he's not guilty of either of these offenses?
No, Your Honor.
Okay, Mr. Hadley, I have a written felony plea form. Have you read this agreement?
Yes, sir.
Have you discussed it with your attorney?
Yes, sir.
Have you signed it?
Yes, sir.
Did you have any questions about anything contained in this written plea agreement?
No, sir.
Now, are you taking any medications at the present time?
Yes, sir.
What medications are you taking?
As of today, I'm on Synthroid, Zoloft, and Prednisone.
And when did you last take those medications?
This morning.
Is that when you're supposed to take them?
Yes, sir.
Do any of those medications or a combination of those medications make it difficult for you to be awake, alert, and aware of what you're doing?
No, sir.
At the present time, are you awake, alert, and aware of what you're doing?
Yes, sir.
And you're aware that you're ending pleas of no contest to 2 charges of first-degree murder. Do you understand that, sir?
Yes, sir.
Okay. Are you under the influence of any illegal drugs?
No, sir.
Are you under the influence of any alcohol?
No, sir.
Now, has any judge ever declared you to be incompetent or incapable of taking care of your personal affairs?
No, sir.
Okay. Now, has either of your attorneys given you any promises or representations as to what sentence will actually be imposed by the court?
No, sir.
And again, you understand, this is an open plea. There's absolutely no plea agreement between you and your attorneys in the state. It'll be entirely up to the court to impose whatever sentences we previously discussed. Do you understand that, sir?
Yes, sir.
Has anybody tricked you, forced you, or making you enter this change of plea?
No, sir.
Now, you've been represented by the Public Defender's Office from the outset of this case. Is that correct, sir, from the beginning? Is that
Yes.
correct?
Yes, sir.
Are you satisfied with the services of all of the assistant public defenders and Ms. Liddy who have been representing you throughout this case?
I am, sir. Yes, sir.
Okay. Is there anything that they have not done that you think they should have done in representing you in this case?
No, sir.
Is there anything that they have done that you think they should not have done in representing you in this case?
I'm sorry, can you repeat that?
Is there anything you think that they have done that they should not have done in representing you?
No, sir.
Okay. Do you need any more time to discuss with your attorneys this change of plea?
No, sir.
Do you need any time to discuss with them whether you should go to trial or whether you should enter this change of plea as a result of all this discussion we've had this morning? You need more time to talk to them about that?
No, sir.
All right, Ms. Liddy, let me ask you, this case is set for trial on March 10. If this change of plea had not been entered, was the defense fully prepared to go to trial at that time?
Yes, sir.
Okay,
We're ready.
Case was ready, prepared,
Yes, sir.
ready to go?
Yes, sir.
Okay. Okay, Mr. Hadley, let me ask you one more question, then the state may have an inquiry. Is there anything else that I should be aware of which would indicate to the court that you're not entering these pleas freely, voluntarily, and knowing all of the possible consequences? Anything else I should be aware of?
No, sir.
And again, you understand that this is the time for you to say so if there is something.
Yes, sir.
That doing it 3 years from now, or 2 years from now, or whatever, after talking to jailhouse lawyers, probably it's not going to be successful for you to get a new trial. Do you understand that, sir?
Yes, sir.
All right, either factual basis or further inquiry?
Yeah, I'll conclude with my factual basis, but if I may inquire, at page 7 of the plea form, your attorney, Ms. Liddy, indicated that she has read you the contents of the plea. Did you understand the contents fully of the plea as she read them to you?
Yes, sir.
Do you have any questions or concerns regarding the contents of the plea as read to you by Ms. Liddy?
No, sir.
All right. Can you read and write?
Yes, sir.
Did you also read the plea form yourself?
Yes, sir.
Okay. I see that you initialed all of the pages of the plea form except the last, number 7. Did you read page 7 as well? It's the signature page that contains your attorney's signature.
I read it.
Okay. And having read, understanding that you read English and understanding that you have read this entire plea form, did you understand it as you read it?
Yes.
Okay. Do you have any questions for the court regarding anything that's contained within the plea form?
No.
All right. At line 5 of your plea offer, which would be contained on page 2, excuse me. Yeah, I'm sorry, it kind of goes on, it's on the top of page 2, it says you check mark the box, or a box was checked for you that says I have previously found to be insane or incompetent. That does not apply to you, correct?
No, sir.
Okay. It also says or admitted to it or committed to a mental facility. Does that apply to you?
No, sir.
Okay. And or I have been treated for a mental health issue. Is that the one that applies to you?
Yes, sir.
Okay. Now, the judge inquired about your medications, and you indicated that you're presently taking Zoloft, some cream, and your Synthroid, which is for the record for your thyroid issues, correct?
Yes, sir.
Were you taking Zoloft at the time you were advised of the contents of the plea form?
Yes, sir.
All right. Were you taking Zoloft while you read the plea form?
Yes, sir.
All right. Does Zoloft in any way, shape, or form affect your ability to think, comprehend, or understand?
No, sir.
Okay. All right. Now at line 9 of the plea form,
Page 2.
Page, what, 9?
I'm sorry, I meant paragraph 9. I say page, I mean 9. It reads, I understand the recommendation for sentencing of the judge by both my attorney and the state is as follows, and that it indicates there is no negotiated plea. Can you tell me what your understanding of that term is?
As in, there's no plea offer made from the state.
Okay. And what do you understand as you stand here today the potential penalty you face in this case could be?
Life in prison without parole.
Okay. And do you understand that the judge could also run a life in prison without parole sentence consecutively, which would effectively be 2 terms of life in prison without the possibility of parole?
Yes.
Do you understand that that means you would never get out of prison?
Yes, sir.
Okay. You understand that in Florida at present, when we talk life, life means life. Do you understand that?
Yes, sir.
Okay. Do you understand that at your sentencing we've discussed here, do you understand this concept of this mitigation hearing, that youth mitigation hearing that we've all been discussing?
Yes, sir.
Okay. What do you understand that to encompass?
It's whether or not to sentence me to life or give me a term of years.
And do you understand that despite this process here where you're entering your plea of no contest, at that sentencing hearing, Mr. Romero and I, on behalf of the people, intend to offer virtually all of the evidence of the case. Do you understand that?
Yes, sir.
Okay, so do you understand that by entering this plea, it is not otherwise prohibiting the release of that information, if you will, in this form? Do you understand that?
Yes, sir.
I'm sorry, explain that again.
Right. At the
Otherwise releasing, I'm not
Right.
sure you understand what that means.
that the evidence will be, it'll come out from witnesses on the witness stand in an open courtroom.
Yes, sir.
Okay.
Okay, just to make sure we're, I understand exactly what he's asking you. There have been some statements attributed to people saying that you thought you might be doing this change of plea to keep the family members from having to go through the trial and reliving all this. Basically, what he's telling you is that he's going to do that anyway. So if you're entering this change of plea to keep your family members from going through that, that's not going to happen. I think that's what you were saying, is it?
Yes.
You understand that, sir? So if you're entering this change of plea because you didn't want to put people through that, that's not going to happen. Do you understand that?
Yes, sir, I understand.
Does that change your mind about entering these changes of plea today?
No, sir.
Okay.
Thank you, Judge. Do you understand that at the conclusion of this youth mitigation hearing, if the judge determines that based upon your circumstances and the facts of the case that you do not deserve life in prison, that the state will be asking the court to sentence you to life in prison with a 25-year minimum mandatory? Do you understand that?
Yes, sir.
Do you understand that when we talk about a 25-year minimum mandatory, that means day for day? Do you understand that?
Yes, sir.
Do you also understand that it will be my intention to ask that you be sentenced to a consecutive terms of life in prison with 25-year minimum mandatories for an effective term, minimum mandatory term of 50 years in prison? Do you understand that?
Yes, sir.
Do you understand that means you would not become eligible for parole until you were 67 years old under the terms of that particular sentence?
Yes, sir.
The plea form indicates that your attorneys explained to you the difference between a direct appeal and a collateral attack. Is that correct?
Yes, sir.
Do you understand the difference between those two terms?
No, sir.
You don't?
No.
It's not my job to inform them of that. I guess I'll leave that to you, or if the defense needs to further advise him, it indicates in the form that he was.
Judge, we, in lay terms, discussed that with him in detail, actually. Did we not discuss with you, Tyler, about collateral attack, which is you can later...
Lawyers.
Right.
I'm sorry, I didn't hear what you said.
Go ahead.
Actually, it was coming back on the lawyer's collateral attack, but I don't understand what the direct appeal is.
You're waiving that.
Your waiver.
When you enter a plea, you no longer
A direct
have a
appeal
direct
means
appeal
that
for the trial.
if you've gone to trial,
Right.
if you were found guilty of these charges or any lesser charges, you could take that appeal to another court for them to review to see whether or not there was some error committed in all these proceedings from the day of your arrest through verdict and sentence. That's a direct appeal.
Yes, sir.
We discussed that.
I just did.
Any more questions?
Okay, so yes, so with that in mind now, you heard your attorneys indicate today that Ms. Liddy filed on your behalf a motion to modify the jury instruction on insanity, which was denied by the court. That would be a matter that you would be able to take up on appeal post-trial. You no longer can appeal that issue. Do you understand that?
Yes, sir.
Okay. Do you understand that if we were to proceed to trial, errors occur during the course of a trial? Errors occur during jury selection. The judge may make certain rulings that are inappropriate. The state may engage in activities that could be appealable. All of these things happen during the dynamics that are a jury trial. And those would be matters subject to appeal that could effectively give you a second bite at the apple. Do you understand that?
Yes, sir.
When you enter this plea today, that's gone. You do not have that option. Do you understand that?
Yes, sir.
Okay. The other issue with respect to the collateral attack is an attack on the advice and counsel given by your attorneys. I'm not asking to get into the details of that. But I do want to understand that as it relates to the potential outcomes I talked to you about, or I indicated for the record what the minimum mandatories are, do you also understand that the consequence of a trial could be a finding of not guilty,
Yes, sir.
which would enable you to walk out that door? You understand that?
Yes, sir.
Okay. Another consequence of that could be one of the lessers we talked about, or a finding of not guilty by reason of insanity. You understand that?
Yes, sir.
Okay. Do you understand that your attorneys have retained experts, in particular an expert who's on staff at Brown University, who's prepared to come into this courtroom under oath in the presence of a jury and advise them that you were insane at the time of the crime? Are you aware of that?
Yes, sir.
Okay. And you understand that's not going to happen now?
Yes, sir.
Do you also understand that other than the insanity defense, and of course a not guilty by reason of insanity would result in you not going to prison but going to a state facility? Do you understand that?
Yes, sir.
And that's not going to happen now. You understand that?
Yes, sir.
Finally, as a result of the testimony of this particular expert, do you understand that he could present sufficient evidence that would suggest that due to the intoxication by Selexia, your SSRIs that you're on at the time of the murders, allegedly, that because of that you could not form the specific intent to commit premeditated murder?
Yes, sir.
You understand that?
Yes.
And that testimony will not be offered to any jury. Do you understand that?
Yes.
And that if that testimony were offered to a jury and accepted by a jury, it could result in you being convicted of one of the lessers that we've already instructed you on. Do you understand that?
Yes.
In the end, as a result of this plea, all of those things that I've just discussed with you are no longer available to you, and you will end up at the same place you would be after trial if you were convicted. Do you understand what I'm saying?
Yes.
Okay. And it's your decision, freely, voluntarily, and intelligently, with full advice of counsel, to enter this plea today.
Yes.
Okay. Nothing further, Judge.
Judge, I have something to add. I would ask the court, or Mr. Bacall, I don't know if he brought the jury instructions over, since the court did request that the lessers be stated here in court that potentially he could receive if he went to trial. I'd ask that the instruction be read as to how a lesser would potentially be brought to a jury's attention, because the instruction is clear that it goes toward, if the state does not prove these charges as charged in the information, there are what we call lesser included offenses. And it goes on to instruct the jury when they're making their, when they're deliberating as to what they would look towards for lessers. I think that needs to be read into the record as well.
You want that jury instruction read?
Correct.
Okay.
Do you have it available? Okay, while you're doing that, can I have the date of the offense, please?
July 16, 2011.
Okay. Mr. Hadley, how old are you right now?
Go ahead.
Mr. Hadley, how old are you right now?
I'm 20.
On July 16, 2011, how old were you?
17.
And while he's looking that up, Ms. Liddy?
I'm sorry, Judge.
Mr. Bacall referenced some experts. Are you intending to call these experts at this juvenile mitigation and sentencing hearing? Are you anticipate
Yes, Your
doing
Honor.
that?
Yes.
So, Mr. Hadley, you're not giving up the right to have these people come and give information to the court. The court helps the court decide what to do regarding sentence. You understand that, sir?
Yes.
You're not giving up that. You understand that?
Right.
Yes,
Thank you,
yes,
Judge.
yes.
Thank you. No.
I guess I gotta get in court a little more often. I should get right to it. That's not what they're talking about. You want the lesser included instruction, right? The language on lesser included?
I think she wants the initial instruction regarding there are some possible lessers.
Right. Yeah, that's what I'm looking for.
Do you have it handy?
Judge, I wasn't anticipating they wouldn't have had it since
Okay.
you had requested it. I didn't get a chance to see what lessons they were going to address the court.
He requested what? I'm sorry, I missed.
No, I just wanted a list of them. I didn't want the instruction read to them.
Well,
Your Honor, I have them.
Okay.
Go ahead and read it.
Okay. In considering the evidence, this is 3.4, standard jury instructions promulgated by the Supreme Court, Florida. In considering the evidence, you should consider the possibility that although the evidence may not convince you, and this is being read to the jury, that the defendant committed the main crimes for which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the defendant is guilty of any lesser included crimes. And then it goes on. The lesser crimes indicated in the definition a first-degree murder with a weapon are those that Mr. Factual read to you.
That's fine.
That's fine.
Okay. Are we ready for factual basis?
Yes, sir. Your Honor, had this matter proceeded to trial, the evidence would have established on the months preceding July 16, 2001, the defendant began ultimately what his parents deemed to be a spiral, if you will. The evidence would establish that his parents, loving, caring individuals throughout his life, were not known to be the most strict of disciplinarians. The defendant began to get in trouble in school, skipping school, dropping out of school, moving schools. He also became heavily involved in drug use. His parents became increasingly concerned about his condition, if you will. They began to discipline him by taking car keys away, by taking his phone away, by limiting his activities outside of the home. The defendant continued to sneak from the home during this time. He was found to be in intoxicated states throughout this period. At some point in time, his parents deemed it necessary to commit him, if you will, to a day treatment program, the RIGA program for his drug.
Your Honor, I'm going to object. This is not an appropriate factual basis for the allegations of what the state has presented in the information or the indictment.
I have to prove premeditation.
I think it may go towards premeditation.
Right. And so the evidence would have established that he was not happy about this fact. In fact, we were prepared, and we will offer at the sentencing hearing extensive Facebook chats between friends where he made disparaging comments about the program, the fact that he was upset with it, and his anger particularly directed towards his mother. The evidence will also establish in the months preceding the murder of his parents, the defendant began to discuss with friends his intention to kill his parents. They will indicate to you at the sentencing hearing that they really just thought he was kidding, didn't take him seriously. There will be actual Facebook chats to that effect as well. The evidence will establish that on July 15, 2011, the defendant was out with family and friends at a dinner. He was, by all accounts, fine. He was amiable. He was conversant. He was better than many had seen him in a long time. The evidence will establish that he told individuals that that very night he had stood over his parents contemplating their murder. He did not do it that night. You will also hear that that day, the 15th, the defendant had talked to a couple of people about throwing a party the next day. You're going to hear that under no circumstances would his parents allow him to have a party. But the days prior to the murder, he was telling people, and again, these will be encompassed within Facebook chats, that he was having a party. All throughout the day of July 16, 2011, he's posting updates to the status of his party. His parents are out of the area in Fort Pierce. We have telephone records that reflect his mother last spoke with her mother at approximately 4:42 p.m. At 8 p.m. that night, the defendant posts on his Facebook page, "Party at my house, hit me up, HMU," and he puts in his dad's telephone number. At that point in time, we would allege that pursuant to conversations the defendant had with his friend Michael Mandel, that the defendant had previously procured a set of hedge clippers with the intent of murdering his parents with that item, but thought better of it on July 16th, instead deciding to use a hammer, a framing hammer, which is a larger type hammer. The evidence will establish that he stood behind his mother, considered, reflected, and just thought of murdering her. The evidence will establish that he began to strike her in the head with a hammer, at which point in time she screamed out, and her husband came from the bedroom. He turned his attentions on to his father and willfully pursued his father into his bedroom, where he proceeded to beat him to death with a hammer. The evidence will establish that before doing that, he took his father's telephone and his mother's purse with the express intent of ensuring that they could not call for help. Afterwards, he cleaned up the crime scene, he showered, he removed various items from the house over hours. He's indicated it took him hours to clean the residence. He communicates with friends advising that the party is still on. He goes out, he takes their bank card, he withdraws cash, which he uses to purchase allegedly marijuana and alcohol, and he throws a party in the very house in which his parents lie dead, bludgeoned to death in the master bedroom. Had this matter proceeded to trial, the evidence would have established that the defendant murdered his parents with premeditated intent on July 16, 2011 in St. Lucie County, Port St. Lucie, Florida.
The court finds that states a factual basis for both counts 1 and count 2, first-degree murder with a weapon. All right, Mr. Hadley, you now need to tell me before I accept your plea, are you entering these pleas of no contest because you are in fact guilty of those 2 crimes, or are you doing so because you believe it's in your best interest to do so?
I believe it's in my best interest to do so.
And further, the court finds that the defendant has freely, voluntarily, and intelligently, upon advice of counsel, entered the pleas of no contest, and the pleas of no contest are accepted by the court. All right, regarding sentencing proceedings, how much time do you need to, both of you, to present whatever you need to do in sentencing, and when do you want, how much time do you need to, the lead time before that separate hearing?
Well, I mean, you set aside this time. I think we should do it as soon as possible, sometime within that window. If the defense needs additional time, perhaps we could start on the 17th, but we had all intended on having our witnesses ready and available for trial, so you have that period open in your calendar. So if we could set aside that week of the 17th, I don't...
The 10th?
Well, the 10th is the first week. Evidence would have began on the 17th, but...
Okay.
I think the 10th's fine, Judge. I thought the court was going to bring in jurors on the 3rd and the first day. I'm sorry, maybe I...
No, the jurors were coming in on the 3rd to pick up the questionnaire.
Oh,
I was going
okay.
down and speak with them. They were to return the questionnaire at some later time. But the first group was coming in on the 10th to begin jury selection.
Oh, I got you, okay.
I don't think the trial was actually anticipated to begin presenting evidence until possibly the second week, the 17th.
Yeah, I mean, that's...
I don't care, either the 10th or the 17th, whether if it meets your schedule. You got everybody ready for those dates?
We're ready for...
We're ready. The 10th is fine, Judge.
That's fine.
All right. And I've got 5 days. You think that's going to be sufficient?
I think so.
Well, how many days do you think you need?
You know, it's hard for me to... I think we certainly, in looking at our trial outline, anticipated a full week of testimony. It's going to, won't obviously be that much testimony. I don't know how much of it will be challenged. So, you know, on the outside, I'm going to guess 2.5 to 3 days, but I know with respect to their experts, I'm going to take at least probably a day on cross-examination, so you can add that in there.
Yeah, Judge, I think that we're going to need probably 4 full days for us, so I think we're going to go into a second week for sure, based on if the state's stating that he's going to spend a lengthy time cross-examining.
Let's do this then. I will start the sentencing proceedings to begin on Monday, March 10. I don't think we didn't set anything earlier that day, because so we'll start at 9 o'clock on Monday, March 10. I have the entire week available to you.
Okay.
I do have the second week available also. And maybe sometime during the first week we can make a decision whether the additional week is needed, because if it's not needed, there are some of the cases
Right.
that I would like to slide in during that time period. But under no circumstances will we need the 24th nor the 31st. Is that...
I wouldn't think so.
No, Judge, I don't think so either.
Okay.
And I'm sorry, go ahead.
Now, I have another issue. So anything else you do regarding the sentencing proceeding?
Yeah, I mean, I guess, you know, I want to ensure that, you know, we're not going to come together and there's some new witnesses. So can I assume the witness list is as it exists today?
No,
No, I can't assume that?
we do have additional people to put on the witness list for the mitigation hearing.
When can you provide that information to the state?
By tomorrow.
Are we talking experts or...
local?
I'm sorry.
Are they local or are they out of state?
They're in the state, Judge.
Are they experts or not, are lay persons?
One is an expert.
Previously not disclosed at all?
No.
It's just unbelievable, but I will schedule a deposition, apparently, you know, I mean, I mean, if we could get that name today, I'll get working on scheduling the depo.
Can you provide that today? I don't mean this moment, but can you provide it today?
Judge, I prefer to provide it tomorrow. Please.
And we can advise the court and state that this particular expert is not somebody that has ever met Tyler Hadley. So it's not that kind of an expert for the mitigation.
Has not and will not before?
Yeah,
Right.
It's an
That's
expert in the
correct.
field.
Yes.
Okay. I have some issues to address. As far as sentencing proceeding, everybody is set for March 10, understand? No other issues?
Yes, sir.
All right, now, I did receive 2 ex parte motions to transport 2 people from DOC.
Yes, sir, I filed those. I don't think they're necessary.
That's what I was going to ask you. Specifically, Dennis Hansen and George Brown, you do not need them to be transported, is that correct?
We do want Mr. Brown, but not Mr. Hanson.
Okay, so I'll do George Brown. I'll enter that transport order, and the order provided for him on or before March 3. Should I keep that date?
Yeah, that'd be good. Thank you.
But Dennis Hansen, no, right?
No, sir.
Anybody
I
else?
would rescind that motion.
Okay. Anybody else you need transported?
No, we've got to make some arrangements, but we'll deal with that.
Okay. Now, anything else from defense?
Judge, as far as the court's procedure regarding this juvenile mitigation hearing, how does the court see it? I mean, are there openings? Are there closings? How?
I think we probably liken it to a penalty phase in a first-degree murder case. The state, I believe Mr. Baccarat agrees he has the burden if he wants me to sentence something other, if he wants me to sentence to life without parole. State agree you have the burden?
Yeah, I think I have the burden of production and probably the burden of persuasion.
So they will go first, and then the defense will have an opportunity. So I think, as you said, this is all new, brand new territory for everybody.
I know.
I think the best way is to liken it to a penalty phase in a capital murder case. Anything else?
No, Judge.
Just for some guidance for the court, if you're so inclined, I think you can go on to lobby tools. I don't know if you have access, but there's a present bill pending. I believe Senator Gates is the sponsor, or I may be wrong who the sponsor is, but there's a present bill pending to address the Miller fix, and it outlines a list of mitigating type circumstances that the court might consider in the future when these hearings become a
Can
matter
you
of...
send that to me?
Yeah, I'll send it to everybody.
Okay, just send it.
Okay.
Yeah, and Judge, just for the record, I know this is not a penalty phase mitigation hearing, so obviously the court is aware that we have to, in the spirit of Miller, consider other things other than what we would consider in a penalty phase hearing. I mean, it's different because it's a juvenile mitigation hearing versus a penalty phase hearing in a death penalty case.
I mean, I think, quite frankly, I intended on asking you at the conclusion of the hearing to put your findings in writing. I think it should be handled exactly like a capital case. That's the most due process you can afford the defendant. It is the best recording of the court's ultimate conclusions and findings relative to the weight you might assign mitigation.
So, at the conclusion of the evidence and conclusion of the argument, if I follow what you're saying, there would not be a decision made. There would be another date set for the court to announce Spencer hearing?
Yeah, if you felt comfortable doing it that way, yeah. I mean, I don't, look, you're the judge, so I want to do whatever you say. I just, in my mind, as I play out how this would work, that's kind of what based on my capital experience, I thought that would be,
Well,
but it does, I mean, if you want to announce it from the bench, that's fair too. As long as, I think you're going to have to make certain findings.
well, I agree. I would have to make certain findings. I think I would be comfortable making oral findings
Okay,
on the record.
that's fine.
And again, this is brand new.
Oh, I know.
It's not like an actual capital death penalty sentencing, which you are required to make certain written findings. We have a Spencer hearing. It's a little bit like, but it's a little bit different too.
Well, Judge, I reread Miller again last night, and Miller does specifically talk about the fact that it isn't the same as a death penalty mitigation hearing. I mean, that's the only reason I'm bringing it up. And Judge, we need a PSI in this case too.
Right, thank you.
Is he entitled to a PSI for capital crimes?
I
I don't think so, but I could be wrong.
I think he is because he has no prior record.
I mean, you can order it. and
Oh, I don't know that it'll be ready by the conclusion of the...
No, I know.
hearing.
It clearly won't. We all also know that there'll be nothing contained in that PSI that isn't brought out during the course of the hearing. So in my humble assessment, it's a doing of a useless act, but I guess you could put off actual sentencing. Huh?
They can do it in 28 days.
Right.
It would be a time.
It's gonna
Based
come
on
out.
the age of the client, we've received PSIs.
Well, you've all gone through homicide cases with juveniles. Aren't there PSIs prepared for... There are?
I don't think we did a
Or
PSI right
is
now.
it a PDR also?
He's
No.
not entitled to a PDR.
Yeah, we checked that out.
Because of the indictment.
Right. The
Takes it out.
PDR is out of the question, but no, I think we need a PSI, Judge. But I think they could expedite it possibly.
Well,
I mean, they
Why
can
can't
do
we
it
just
quick.
have the hearing and then come back for sentencing if we got to wait?
I may have to do that. All right. I will order a pre-sentence investigation report be prepared. I doubt seriously that it'll be available at the conclusion of the evidentiary mitigation hearing, but we'll see. So I may have to set it actually for another sentencing date after that.
And the defense doesn't object to that,
No.
waiting for the PSI.
No, if it's not
And as
done.
they've requested, it's got to be done, so.
Judge, again, I don't think we have a choice in this.
Okay, then that's fine. I'm just saying it's not going to be ready at the conclusion of the evidentiary hearing. There'll have to be a subsequent actual date for sentence to be imposed.
I understand.
Okay. Anything else?
No, sir.
Anything else?
Thank you, Judge.
One more thing, Mr. Hadley. Have you completely understood everything we've done from the first time you were brought out here this morning until right this moment?
Yes, sir.
Do you have any questions or objections about anything that's occurred so far today?
No, sir.
And are you still wanting to enter your pleas of no contest to these 2 counts of first-degree murder with a weapon?
Yes, sir.
Okay. All right, we'll see you then on March 10th at 9 a.m.
Thank you very much, Judge. We appreciate it.
All right, we are in recess.
Oh my gosh. I like to pretend I don't.
Do your best. I know you
When you guys are ready,
I love